Affairs Division of the Ministry of Law, Justice and Parliamentary Affairs since August 2020. He had his LLB honors and LLM from the University of Dhaka. He served as Senior Assistant Judge prior to his joining the Ministry of Law, Justice and Parliamentary Affairs, where he worked as Deputy Secretary, Joint Secretary, and Additional Secretary before assuming his present assignment. Mr. Kabir traveled to USA, UK, Canada, Australia, Singapore, and India on various training programs and study tours. He's a life member of Commonwealth Association of Legislative Councils and the Asian Association of Legislative Councils. I would now request Mr. Moinul Kabir to say a few words.
Thank you. Can you hear me, sir? Can you hear me?
Yes,
You are
sir,
loud and clear. Yeah.
Thank you very much. Thank you very much for introducing me, Mr. Moderator, Honorable Chair, Honorable Moderator, panel discussants, guests, ladies and gentlemen around Bangladesh and around the world. Assalamu alaikum and very good morning. It is a matter of great pleasure for me and honor for me as well to be with you in this morning. I welcome the session titled ADR Can Create Faster Access to Justice. May I request you to have some sort of little discussion on the alternative dispute resolution mechanisms, which are believed to be a consensual approach to the settlement of this dispute, not following the intractable formalities of the existing adversarial trial system. It is described as informal, confidential, expeditious, effective, mutual participatory, cost and emotion effective, as well as promoter of peace and social harmony by removal of enmities and contributed to a breakthrough in prevailing crisis of backlogging of cases. The alternative dispute resolution or ADR schemes are not a new phenomena in our society, but never widely used for formal civil process. What is now is the extensive promotion and proliferation of the ADR models, and it's increasing regularly. The traditional Shalish system was practiced in the community level for the settlement of disputes during old age eras in the subcontinent, as well as the Panchayat model during the British and early time. They used to resolve minor disputes within the local area and are practiced all over Bangladesh and India as well till now. And mediation process, especially in family-related matters, is a popular method of dispute resolution to the marginalized people of the country due to their enthusiastic approach to the settlement. Though the traditional Salis has the potential utilities, considerable advantages of the parties and effectiveness, it is now increasingly losing credibility due to imposing the arbitrary decision on the reluctant disputants by the intellectual personals and powerful influential personals of the village. But court-annexed ADR schemes are the very recent development in Bangladesh and achieved a tremendous success to settle the disputes in alternative way with the intervention of the court. It has created great expectations and hopes to the litigant people, because when a dispute is settled expeditiously with the saving of cost and time of the parties in an amicable way under the supervision of the court, it is likely to ensure integrity, impartiality, and authenticity of the mechanism. The incorporation of compulsory ADR mechanism in family code has effectively opened the wide windows for delivering justice to the people concerned. The very recent development of ADR in civil suits, both in trial and appellate stages and in commercial disputes, reflect a paradigm shift from traditional litigation to ADR for enhancing access to justice. These newly inserted provisions of ADR in different legislations of Bangladesh have created a vast opportunity of access to justice for all, especially for the poor or disadvantaged groups of people who cannot go to the court due to their financial constraint, or if they even go to the court, they cannot equally move against the strong opponent who engage vet an expensive lawyer for their financial situation. Invariably, ADR has a very significant role towards the enhancement of access to justice, avoiding all kinds of procedural and other complexities. ADR, in compared to the regular courts, keeps efficacious and effective role for the promotion of access to justice by ensuring consensual settlement, actual participation of the parties, reducing costs and saving the time and energy of the parties. Realizing the great success of ADR, almost all the countries of the world have inserted the provisions of ADR in the civil and criminal justice system. In Bangladesh, our scenario is quite, I think, a little bit better from earlier stages. The existing legal regime is quite consistent with the ADR process. The basic statutes governing the ADR system in our country are as follows. Code of Civil Procedure 1908, Muslim Family Laws Ordinance 61, the Customs Act 69, Income Tax Ordinance 84, Family Code Ordinance 85, the Legal Aid Services Act 20,000, the Arbitration Act 21, the Money Loan Code Act 23, the Conciliation of Disputes, Municipal Areas Board Act 24, the EPZ Trade Union Industrial Relations Act 204, the Village Courts Act 26, Bangladesh Labor Code 26, Value Added Tax 2012, and EPZ Labor Code 2019. Apart from all these, the Bank Companies Act 1991 in its section 76 provides for the settlement of disputes between the bank and the creditor by way of amicable settlement of disputes. The Contract Act 1872 in its section 28 provides for facilitation of dispute through arbitration. Further, I mentioned that the Chittagong Hill Tracts Land Dispute Settlement Commission Act 2001 provides for recovery of unlawful possession of land following the local customs and uses, which may not be considered as traditional adjudication of process. Moreover, I must say that various types of ADR are practiced in Bangladesh, namely judicial or court-based ADR, formal statutory ADR, informal ADR, and some other non-formal ADR as well in the name of arbitration, mediation, conciliation, and negotiation, and many other. Now, access to justice, this connotation is granted as a fundamental right almost in every democratic country of the world. Bangladesh Constitution confirms the Republic shall be a democracy. Republic shall be a democracy in which fundamental human rights and freedom and the respect of the human dignity shall be granted, and equality before law, equal protection of law ensured, and the right to fair trial is protected. The concept of access to justice includes the whole range of laws, procedures, and institutional arrangements through which justice can be delivered to the people in efficient and effective manner. And it denotes the instrumentalities by which citizens can approach the court. Citizens can approach to the court, the lawyers, the legislatures, judges, administrative units for both substantive and procedural justice. In 1994, the Commonwealth government, all the governments, appointed the Access to Justice Advisory Committee, which stated the access to justice involves equality of access to legal service for all, national equality for all, and equality before law. Efficiency and effectiveness of ADR towards access to justice is needed in all works. Development of ADR in different countries of the world, especially in developing countries, is a step towards the proper administration of civil justice for all equally and with equity. It has successfully opened the door of justice for rich and poor, which the ordinary legal system cannot do in every sphere. Through ADR, the parties can reach to a harmonious settlement of the dispute, which is opposed to the win-lose outcome of the legalistic and formalistic approach of litigation. Usually, the win-lose situation becomes a rigorous obstacle in the way of future relationship between the parties, as it equals win-win situation, which not only settles the dispute, but also brings peace and healing that preserve the future relationship between the parties as well. Avoiding all kinds of legal procedural complexities, technical legal principles, it follows the process which the parties and their appointed mediators think best for the settlement of their issues. In ADR, the parties select and control the process of it for smooth, correct, effective, and efficacious remedy, and they are under the liberty to appoint an expert in the subject matter of the dispute. Through ADR, avoiding formal process of the court, it is not impossible to settle more than one suit in a single sitting, which not only saves the time and energy of the litigants, but reduces the cost to a significant extent. Apart from ensuring these benefits, it can provide social and psychological benefits to the parties. So a vast number of disputes are settled through ADR, which enormously reduces the tremendous pressure on the current source in the regular source in the ordinary course. One important positive side of ADR is absolutely maintaining of privacy, because privacy is a key value which underpins human dignity and social justice. And it is a basic human right and legitimate expectation of every person. Once a mediation settlement is reached and a decree is passed or a word is passed, the case is finally disposed of. Unlike a trial, there is no possibility of a dispute settled through mediation being revived. Another important advantage of ADR is the liberty of the parties to withdraw the suit at any time in any stage of the proceeding from the formal court and to send for the settlement through ADR. And resolution through formal ADR bears the strength of a judicial decree that is expected to contribute greatly towards the level of confidence and popularity of the mechanism amongst litigants. The informality of ADR, particularly mediation, paved the way for the marginalized people and grassroots members of the community to participate in local adjudication process. This participatory system is unique one. For these advantages of ADR, judicial mediation and arbitration have been introduced in many parts of the world and in many legislations in Bangladesh, and people of this country and this region are also seriously benefited by this process. Of course, there are some sort of disadvantage as well, because when a person requires some sort of interlocutory matter like injunction or some interim orders from the court, ADR cannot help. But I think over the time, this sort of impediments will be overcome as well. In fine, I must say that delayed justice even sometimes fail to give proper remedies to a winning party too. Litigation cost in a civil suit is too high in terms of time, money, energy, and human expectations. In this context, ADR offers many advantages through which a dispute of all kinds can be disposed of quickly and inexpensively. The present judiciary of Bangladesh has caught in a vicious circle of delays and backlog of cases. The backlog of cases is prolonging the whole trial process. As a result, the justice seekers are suffering from many hurdles, losing their confidence in the judiciary. The process goes on with no apparent remedy in view. Present rate of disposal of cases and backlog is alarming for justice, rule of law, and economic development of the country. So, ADR, a fair and right process like ADR for resolving disputes is crucial in any civilized society for the purpose of securing the defining rights of its citizens of this country. I must say that I'm grateful to BIAC for giving me the opportunity to say a few words on the access to justice system of Bangladesh. I also congratulate BIAC on the occasion, this advance congratulation on the occasion of its 9th anniversary. Thank you all for listening me. Thank you very much.
Thank you, Mr. Secretary. Thank you very much for the insight and your overview of the evolution of ADR in the country. And you have rightly said that it is a consensuous settlement to save time and cost, and existing ADR-friendly legal setup, as you said, is going to support ADR. We welcome your initiative. As you have said that interlocutory matters cannot be dealt with by ADR, it's true. Businesses don't want any interim orders. They want resolution once for all. So ADR is preferable for the businesses to settle their disputes, as we opine. Now we have the speakers, panelists. We have 8 in hand. In the meantime, we have our chairman, Mr. Mahbubur Rahman, who will be joining very soon. Our CEO, Mr. Muhammad Erumi Ali, is already here. Now I would like to introduce the first panelist, Mr. Muhammad Sirazul Islam, who is the executive chairman of Bangladesh Investment Development Authority, BIDA, the principal private investment promotion and facilitation agency of Bangladesh. Mr. Islam served Bangladesh Civil Service in various key positions, including Secretary, Ministry of Health and Family Welfare, Secretary, Election Commission, and so on. He had his MBA from the University of New Orleans, USA, and studied law and public administration in the University of Dhaka and University of Canberra, Australia. Now it is your turn, sir, Mr. Muhammad Sirazul Islam.
Thank you very much. I believe that you can hear me. Can you hear me?
Yeah, you're audible.
Okay. Thank you. Respected Chairman BIAC, Mr. Mahbubur Rahman, distinguished Secretary, Legislative and Parliamentary Affairs, Mr. Moinul Kabir, my friend Moderator, Mr. Ali Akmall, Hossain Azad, and distinguished panelists, ladies and gentlemen, Assalamu alaikum, and I think it is already noon or afternoon. Well, I'm not an expert on ADR, but as I have been introduced, I'm working as the executive chairman of BIDA. I have some interest in ADR, so it's my privilege, and I'm really thankful to BIAC for inviting me to this very important webinar. As the secretary, in his opening space, he set the tone of this webinar. He has given the overview of ADR. He talked about various mode of ADRs, including the age-old Salish, the village code, and so on. But I will be rather interested in the dispute resolution of the businesses. And as all of you know, and perhaps there is no disagreement in the saying that our legal system, which is really, what I should say, very lengthy process, the adversarial system. And as the legal adjudication of disputes takes a longer time, it also incurs more expenses. So something alternative should be thought of. And that alternative might be in many shapes. As the secretary already mentioned, that it can be mediation, it can be arbitration, it can be just reconciliation, or in maybe other moods also. But I would like to keep myself, as the time is limited, within the mediation and arbitration. Mediation is really a very effective way of resolving disputes, provided that the disputing parties agree to the opinion or the expert opinion of the mediator. And that's very simple. Just when you are in a dispute, choose someone, we will give you expert opinion and make both the parties settle their dispute. That's the simplest one. But as I believe, there is no legal backup of the mediation yet in our country. So it is quite informal. Doesn't matter, even if it is informal, if we can resolve our differences, that's fine. But I would like to talk on the arbitration. Arbitration is the alternative dispute resolution, which is very, very important so far the business disputes are concerned. As our country is progressing, and we have a lot of economic development, a lot of economic activities, both within the country and internationally. There is every likelihood that the businesses will face disputes. That there could be differences between or amongst the parties. And if they go to the formal course, that we have mentioned, that it takes a longer time. It takes years and sometimes ages. So once two businesses engaged in civil litigation and they go to the formal course, perhaps there is little hope that they can continue with their business anymore. So some alternative should be there. And the Arbitration Act 2001 sets that platform for resolving their dispute outside court. That law also provides for provision for implementation of the foreign arbitration hours also. But I want to deal with some of the limitations of this act, which I believe is very important. We need to overcome those limitations. This act, in fact, provides for a limited time for formation of the arbitral tribunal. There are limited time for each of the steps that parties and the courts need to take. But when the arbitration itself, the process starts, there is no limitation of time. And I have been told by some of my students that it takes 4, 5, 6 years for the disposal of the arbitration case by the arbitral tribunal. Then I don't know what is the purpose of forming this arbitral tribunal. So we need to have some provision. Government needs to think seriously about limiting time for disposal of the arbitration process itself. Then the question of execution of arbitration award is there. It is like any other decree of the civil court, and you need, if the parties agree, fine, no problem. The arbitration award could be final. And if the parties agree, they can maintain a very good relationship and the business can continue. But if it goes to other, if it is challenged, then there is provision for a petition for setting aside and also for appeal. That takes also a very longer time. The execution of the arbitral award, if not agreed by the one of the parties, then it takes the shape of a decree of the civil court, and you need to institute another civil case, which is called execution suit, and that takes also 4 or 5 years. And I have been told yesterday by one of our leading businessmen that there was a case which was settled in 2005, and that has not yet been finalized. So these are the things government needs to think very seriously, because so far I am concerned, whenever I meet the business delegation, particularly some of the foreign investors, when they come and talk to me, they talk about the judicial system, the lengthy process, and also enforcing the contract. These are really, we are in a real bad shape. As you know, in the ease of doing business global index, we are in 168 rank out of 190, but the indicators of enforcing a contract, we are at 189 out of 190, meaning our system is really bad in this case. The World Bank come to a conclusion that in average, business dispute takes more than 1,400 days, 1,400 days in average to settle, which in fact put our condition, our position in a very bad position. So we need to limit ourselves in this also, and to improve the ease of doing business rank, we need to have some good ADR so that disputes can be resolved quickly and with little cost, which is really needed for the business. Thank you very much. I stop here.
Thank you, Mr. Executive Chairman. Thank you for your in-depth discussion on the issues. Especially, you have pointed out a few limitations of the Guiding Law Arbitration Act 2001, and you have a few suggestions which are well taken. And we look forward to work together with BIDA, as you have enlightened us with some statistics from the World Bank Doing Business Global Index. We're lagging behind. Why we are lagging behind? How can we resolve all these things? By adopting ADR methods in disposing of business disputes, we can work together with you. Thank you, sir. Now I will introduce Mr. Fowzul Azim, the Chief Research Officer of Law Commission Bangladesh and a Senior District and Sessions Judge. He studied law in the University of Dhaka. He's an LLM on environmental law from the Australian National University, Canberra. Mr. Azim was a lawyer, human rights activist, teacher, and journalist before joining Bangladesh Judicial Service. He traveled to India, Australia, the Philippines, Canada, UK, Nepal, and Saudi Arabia on various training programs and study tours. Mr. Fowzul Azim, the floor is yours.
Thank you very much, sir. But I want to like to speak in Bangla. And first of all, I thanks of you all. Just আমি প্রথমে বলতে চাচ্ছি, আপনারা যে টপিকটা আছে কথা বলতে বলেছেন, সেটা হচ্ছে ADR can create first access to justice. আমি এখানে একটু বাড়তি শব্দ যুক্ত করে আমার বক্তব্যটা বলতে চাচ্ছি, সেটা হচ্ছে কোর্ট বেস ADR ক্যান ক্রিয়েট ফাস্টার অ্যাক্সেস টু জাস্টিস। এই জায়গাটা আমি আসতে চাই। তার আগে আমি সচিব মহোদয়কে ধন্যবাদ জানাতে চাই, কারণ উনি খুব ওনার ওয়েলকাম স্পিচে খুব বিশদভাবে বলেছেন যে আমাদের ADR-টা কি পজিশনে আছে। আমাদের ফর্মাল, ইনফর্মাল, নন ফর্মাল ADR রয়েছে, প্লাস আবার পোস্ট বেস ADR রয়েছে। যেহেতু আমি 26 বছর জুডিশিয়ারিতে কাজ করেছি, সেহেতু আমি জাস্ট কোর্ট বেস ADR এর বিষয়ে কিছু বলতে চাই। এখানে প্রথমেই বলতে চাচ্ছি যে যেটা সচিব মহোদয় বলেছেন, বাংলাদেশে এখন যে আইনগুলো প্রচলিত আছে তার মধ্যে 14টা আইনের মধ্যে অল্টারনেটিভ ডিসপিউট রেজুলেশন, কোর্ট বেস রেজুলেশন স্কোপ আছে। তো তার মধ্যেও আবার যদি আমরা আরেকটু ক্যাটাগরি করি, খুব অ্যাক্টিভলি কোন 4টা জায়গা, 3-4টা জায়গা আছে। অ্যাক্টিভলি আছে হচ্ছে আমাদের ফ্যামিলি কোর্টে, আমাদের সিভিল কোর্টে, আমাদের লোন কোর্ট বা অর্থঋণ আদালতে। এই 3টা জায়গায় আছে যেটাতে আমরা খুব ডেইলি এই জিনিসগুলো পেয়ে থাকি। তার মধ্যে সবচেয়ে এই 3টা যদি আমরা ধরি, সবচেয়ে যদি আমাদের কিছু সাফল্য এসে থেকে থাকে, যেটা আমাদেরকে অ্যাক্সেস টু জাস্টিসে ফাস্টার রিমেডি দিচ্ছে, সেটা হচ্ছে ফ্যামিলি কোর্ট। আমি নিজে ফ্যামিলি কোর্টে কাজ করেছি 12 বছর, এবং এই 12 বছরে ফ্যামিলি কোর্টে কাজ করার অভিজ্ঞতা থেকে আমি দেখেছি যে এখানে সবচেয়ে বেশি রিলিফ দেওয়া যায়। কারণ এই আইনটা প্রি ট্রায়াল এবং পোস্ট ট্রায়াল দুটো স্টেজে, অর্থাৎ ইস্যু ফ্রেম করে মামলা শুরু করার আগে একবার দুই পক্ষকে নিয়ে বসে মীমাংসা করে দেওয়ার সুযোগ আছে। এবং সেখানে কখনো কখনো দেখা যাচ্ছে যে দুই পক্ষের অভিভাবকদেরকে নিয়ে এবং কখনো কখনো আইনজীবীদেরকে বাইরে রেখে এই জিনিসটা করা সম্ভব, এবং খুব সহজেই এটা সহজেই করা যায়। যদি কোর্ট খুব প্রোঅ্যাক্টিভ হয়, খুব চেষ্টা করে থাকে, তাহলে এটা আমরা এখানে খুব অনেক সাফল্য পেয়ে থাকি। এবং শুধু তাই না, এটা একমাত্র এই আইনেই আছে। যদিও সিভিল কোর্টে, কোড অফ সিভিল প্রসিডিউরে আমরা দেখেছি যে অ্যাট এনি স্টেজ কম্প্রোমাইজ করা যায়, কিন্তু এই আইনে একটা ম্যান্ডেটরি ম্যাটার আছে যে সমস্ত সাক্ষ্য প্রমাণ শেষ হয়ে যাওয়ার পরে আর্গুমেন্ট নেওয়ার আগে আরেকবার পোস্ট ট্রায়ালের পরে, প্রি ট্রায়ালের পরে পোস্ট ট্রায়াল আরেকবার দুই পক্ষকে নিয়ে বসার সুযোগ আছে, এবং সেখানেও অনেক মীমাংসা হয়ে যায়। আমরা সেটা আমাদের অভিজ্ঞতায় পেয়েছি। তাহলে সবচেয়ে সাকসেসফুল জায়গা হচ্ছে 80। আর আমরা 89 CPC তে যেটা আছে, আমাদের আদালতে আছে, দেওয়ানি আদালতে আমাদের আসলে এটা যখন 1908 সনে দেওয়ানি সিভিল কোড অফ সিভিল প্রসিডিউর কোডিফাই করা হয়, কিংবা আমাদের ক্রিমিনাল প্রসিডিউর 1898 যখন কোডিফাই করে, দুই জায়গায় কিন্তু কম্প্রোমাইজের কথাটা আছে। ক্রিমিনাল সাইডে কম্পাউন্ডেবল এবং নন কম্পাউন্ডেবল সেকশন গুলো রয়েছে, যেগুলো আউট অফ কোর্ট মীমাংসা করে আনা যায়, এবং সিভিল কোর্টেও এই জিনিসটা আছে। সিভিল কোর্টে এই জিনিসটা অর্ডার 29 রুল 3 তে একদম পুরো স্পষ্ট বলা আছে যে এই কম্প্রোমাইজ অফ সুট আউট অফ কোর্ট করে এনে যাওয়া যাবে, এবং একটা সোলে নামা দাখিল করলে সোলে ডিক্রি হতে পারবে। সেটা ওখানে যে কোনো সময় এটা স্কোপটা ছিল। 89 এতে যেটা করা হলো, 89 এতে আমরা 2009 এসে করলাম যে মেডিয়েশন, আরবিট্রেশন এবং মেডিয়েশন ইন অ্যাপিল, এই গুলো ঢোকানো হলো, এবং মেডিয়েটর কারা হবে, তাদের প্যানেল ইত্যাদি অনেক বড় একটা সেকশন দিয়ে সেই প্রসিডিউরটা আমরা ইন্ট্রোডিউস করলাম, এবং এটা ম্যান্ডেটরি করা হলো 2015 সম্ভবত, এটা 2015 কিন্তু যে এইটাতে খুব বেশি সাফল্য আসছে না। কারণ হচ্ছে যখন আমরা মামলাটা দুই পক্ষ অলরেডি লয়ার এঙ্গেজ করে ফেলেছে, এক পক্ষ আর্জি দাখিল করে মামলা করেছে, আরেক পক্ষকে ডেকে আনা হয়েছে সমন দিয়ে, তারপরে সমন জারি করা হলো, তারা দীর্ঘ সময় নিয়ে বারবার সময় নিয়ে রিটেন স্টেটমেন্ট দাখিল করলেন, অল বেসিক ডকুমেন্টস দাখিল করলেন, তারপরে যখন যায় দুই পক্ষের মধ্যে এক ধরনের কন্টেস্টিং মুড চলে আসে, যার ফলে এইটা, এবং এর মধ্যে লয়ারদের একটা ইন্টারেস্ট থাকে, এবং লয়ারও অনেক সময় এটাতে একটু রিল্যাক্টেন্ট থাকেন যে এত তাড়াতাড়ি মামলাটা শেষ করে দেওয়ার ক্ষেত্রে। এবং যার ফলে হলো কি, আমার অভিজ্ঞতা অনুযায়ী 89A থেকে আমরা শুধু কোনো রেজাল্ট সেভাবে পাচ্ছি না, বরং আমরা যেটা পাচ্ছি সেটা হচ্ছে আরেকটু ডিলে হয়ে যাচ্ছে। আগে আমার যে কয়টা স্টেজ ছিল তার মধ্যে নতুন করে 89 এর একটা স্টেজ যাচ্ছে, তাতে আমার 10-12 দিন সময় লেগে যাচ্ছে, অথবা কখনো কখনো এটা মাস 2 মাসও লেগে যেতে পারে। সুতরাং এটা দিয়ে আমার আসলে ওয়েস্টেজ অফ টাইম হচ্ছে, এটা দিয়ে আমি অ্যাক্সেস টু জাস্টিস বা ফাস্টার অ্যাক্সেস টু জাস্টিস খুব একটা এক্সপেক্ট করতে পারছি না। এবার আসা যাক অর্থঋণ আদালতেও এই জিনিসগুলো আছে। অর্থঋণের সেকশন 22, 25, 28, 38 এই সমস্ত ম্যান্ডেটরি মেডিয়েশনের কথা আছে, আরবিট্রেশনের কথা আছে। এটাও যে খুব সাকসেসফুল হচ্ছে এমনটা না, কারণ আমি যতটুকু দেখেছি তার মধ্যে, কারণ দুই পক্ষের মধ্যে ডিসপিউট যেগুলো থাকে সেগুলোতে ব্যাংকের অনেকটা রিল্যাক্টেন্সি থাকে, সব তথ্য একসাথে দেয় না। তারপর তাদের যে সমস্ত জিনিসগুলোতে ছাড় দেওয়ার ব্যাপার থাকে মেডিয়েশনে, সে সমস্ত ব্যাংক কর্মকর্তারা যারা মেডিয়েশনে আসেন তাদের ক্ষমতা থাকে না। তারপরে এইরকম অনেকগুলো প্রবলেম এইসব জায়গায় থাকে, যে কারণে এখানেও যে খুব বেশি ফ্রুটফুল যতটা আশা করা যাচ্ছিল, কারণ এটা একটা কমার্শিয়াল ডিসপিউট। আমরা জানি, একটু আগে আমাদের আকমল স্যার কিংবা আমাদের আগে যে দুজন বক্তা বলেছেন, তারা সবাই এটা বলেছেন যে কমার্শিয়াল ডিসপিউটে এটা খুব সহজে সমাধান করা সম্ভব। কমার্শিয়াল ডিসপিউটে যেহেতু কমপ্লিকেটেড লিগ্যাল ইস্যুগুলো থাকে না এবং ক্রস কানেক্টিং ইস্যুগুলো খুব কম, সেক্ষেত্রে কমার্শিয়াল ডিসপিউটে অনেক সহজে আমরা এগুলো মীমাংসা করতে পারি। কিন্তু কেন এটা অর্থঋণে করা যাচ্ছে না, সেটার ব্যাপারে আসলে একটু গভীর গবেষণার প্রয়োজন আছে, নেওয়ার প্রয়োজন আছে। এবং প্রয়োজন হলে ব্যাংকগুলোর যে ধরনের অ্যাটিটিউড আমরা দেখতে পাচ্ছি, সেগুলোতে কিছু পরিবর্তন করা দরকার আছে, এবং সেটার আইনগত যদি কোনো ভিত্তি না দেওয়া হয় তাহলে ব্যাংকগুলো সেভাবে হয়তো পারবে না। কাজে এই জায়গাটায় আমাদের খুব বড় রকমের পরিবর্তনের একটা বিষয় আমরা দেখতে পাই। এখন ব্যাপার হচ্ছে যে এইখানে মূল বাধাটা কোথায়। আমি আমার অভিজ্ঞতা থেকে বলবো, আমাদের সচিব মহোদয় এখানে আছেন, তিনি অনেক দীর্ঘ সময় ধরে আমরা একসাথে কাজ করেছি, অনেক কাজ শিখেছি তার কাছ থেকে। আমি এই কম্প্রোমাইজ ডিগ্রি অথবা সোলে ডিগ্রির কথা বলবো, সেটা দিয়ে আমি অভিজ্ঞতাটা কথা বলতে চাই যে সোলে ডিগ্রিটা কিরকম হয়। আউট অফ কোর্ট দুই পার্টি লয়াররা একটা সোলে নামা লিখে নিয়ে আসেন, আমাদের কোর্টে প্লেস করেন, সেটার উপর একটা শুনানি হয়, তারপর এটা অর্ডারের জন্য থাকে। যখন অর্ডারের জন্য থাকে তখন আমাকে এটা খুব কেয়ারফুলি করে তারপরে অর্ডারটা দিতে হয়, এবং অর্ডারের মধ্যে একটা শব্দ দুটো শব্দ লিখতে হয়। আমাদেরকে সচিব মহোদয়রা শিখিয়েছিলেন যে ইট মাস্ট বি ফেয়ার এন্ড লিগ্যাল, যথাযথ এবং আইনানুগ। তিনটা শব্দ লিখে যদি এই আমি যথাযথ এবং আইনানুগ পাই, তাহলেই কেবল আমি এটার উপরে কম্প্রোমাইজ ডিগ্রি দেবো, না হলে দেবো না। এখন আসুন যে যথাযথ এবং আইনানুগ, লিগ্যাল এন্ড ফেয়ার হওয়ার ক্ষেত্রে আমাকে কি কি জিনিস দেখতে হবে। সেখানে আমাকে যেসব জিনিসগুলো দেখতে হয়, সুটল্যান্ড ইত্যাদি ইত্যাদি বিষয়, আমরা অনেক ক্ষেত্রেই দেখেছি যে দুই পক্ষ দুই ভাতিজা মিলে মামলা করে তৃতীয় চাচার সম্পত্তি, যেটা এই মামলার বিষয়বস্তু না, নট এ ম্যাটার অফ সাবজেক্ট ম্যাটার অফ দিস সুট, সেটার উপরে কম্প্রোমাইজ ডিগ্রি ফাইল করে দিয়েছেন। এবং অনেক অনেক ক্ষেত্রে যেগুলো ডিগ্রি স্টেজের মামলা গিয়ে আমরা অ্যাপিলের স্টেজে পেয়েছি, যে অনেক অনেক ক্ষেত্রে কোর্ট এগুলা ঠিক মতো অ্যাডজুডিকেট না করতে পারার কারণে ডিগ্রি হয়ে যাচ্ছে, যেটা হচ্ছে পুরোপুরি একটা নন সুট ল্যান্ডের উপরে। ফলে ইট ক্রিয়েটস মোর প্রবলেম। তো সেক্ষেত্রে যেটা প্রয়োজন ছিল যে আমাদের লয়ারদের এখানে অ্যাকাউন্টেবিলিটি প্রয়োজন রয়েছে, অ্যাজ ওয়েল অ্যাজ আমাদের কোর্টের এই জিনিসটা খুব ভালো ট্রেনিং এর দরকার আছে। আমি এখন এই জায়গাটায় আসবো, কেন আমাদের দেশে কোর্ট বেসড এরিয়াটা কেন সাকসেসফুল হচ্ছে না। এটার মূল কারণ হচ্ছে আমাদের যথেষ্ট ট্রেনিং নেই, এবং এর জন্য ইনডেপথ রিসার্চ করে আমরা আমাদের আইনজীবী, আমাদের বিচারক যেমন ট্রেনিং প্রয়োজন আছে, মেডিয়েশনটা কিভাবে করতে হবে, এডিআরটা কিভাবে করতে হবে। কারণ আমাদের ইউনিভার্সিটিতে এখনো যেভাবে পড়ানো হয় শুধু থিওরিটিক্যাল সাইডটা পড়ানো হয়। যেভাবে একজন আইনজীবী কিভাবে এডিআরটা মেনটেন করবেন, একজন আরবিট্রেটর কিভাবে করবেন, সেইভাবে এই নানা মাল্টি অ্যাঙ্গেল থেকে এটাকে পড়ানো হয় না বা শেখানো হয় না। যার ফলে, এবং আমরা যারা বিচারক বা আরবিট্রেটর থাকি বা যে কোনো পর্যায়ে থাকি, সেটা লেখার জন্য যে যে জিনিসগুলো আমাকে লিখতে হবে, অর্ডারটা লেখার ক্ষেত্রে যতগুলো জিনিস কি আমরা এক্সহস্টিভ করে লিখতে হবে, সেই টেকনিকগুলো আমাদের হাতে কলমে শেখা দরকার রয়েছে। এই জায়গাগুলো খুব সিরিয়াসলি দেখতে হবে। দুই নাম্বার হচ্ছে আমাদের আইনগুলোকে, যে সমস্ত আইনগুলোতে এটা আছে, এটাকে ডেপথ রিসার্চের মাধ্যমে এর প্রবলেমগুলো বের করে এবং সেগুলো অ্যাড্রেস করে আইনগুলোকে ওইভাবে আপ টু ডেট করার প্রয়োজন আছে। ট্রেনিং এর কথা আমি বলেছি, সেটার করা দরকার। এই এডিআর এর ট্রেনিং এর জন্য শর্ট কোর্স করতে হবে। ইউনিভার্সিটিগুলোর সাথে কোঅপারেশনে করা যায়, বার কাউন্সিল করতে পারে, জাটি করতে পারে, এবং প্রয়োজন বোধে এগুলোর উপরে আলাদা ডিপ্লোমা দেওয়া যেতে পারে। যারা এই সমস্ত ডিপ্লোমাধারী থাকবেন তারাই কেবলমাত্র এই এডজুডিকেশনটা করবেন অথবা এই আরবিট্রেশনটা করবেন, এই লয়ার হিসেবে, অ্যাজ এ আরবিট্রেটর, অ্যাজ এ লয়ার, হোয়াট এভার ইট মে বি। এবং এগুলো বিয়াকের মতো প্রতিষ্ঠানও এই ধরনের ট্রেনিং এর জন্য এগিয়ে আসতে পারে। আমার বিশ্বাস তারাও এই ধরনের ইন কোলাবোরেশন ইন ইউনিভার্সিটি অর এই ধরনের কাজ করতে পারেন। তাহলে এই দুটোর পাশাপাশি সবচেয়ে বেশি যে জিনিসটা লাগবে, এই তিনটের জিনিসের পরে যে জিনিসটা সবচেয়ে বেশি দরকার হবে, সেটা হচ্ছে মোটিভেশন প্রোগ্রাম। অ্যাকচুয়ালি যদি উদ্বুদ্ধকরণ কর্মসূচি না থাকে জনগণের মধ্যে এবং সব জায়গায়, এবং এই জিনিসগুলো যদি আমাদের স্কুল কলেজ পর্যায়ে যদি আমাদের লিগ্যাল সিস্টেমের উপরে শর্ট পড়াশোনার একটা সুযোগ থাকে পাঠদানের, সেখানে যদি এটা খুব হাইলাইট করা যায় যে আমরা এইভাবে ডিসপিউট রেজলিউশন করা যায়, বিরোধ নিষ্পত্তি করা যায়, তাহলে পরে এটাতে আমরা অনেক বেশি ফল পাবো। এখন ব্যাপার হচ্ছে যে এইগুলো করার ক্ষেত্রে আমাদের গভীর গবেষণার দরকার আছে। আমি আইন কমিশনে কাজ করার সুবাদে আমি বলছি যে আইন কমিশনের এখন যে লক্ষ্যটা বা যে উদ্দেশ্যটা সেটা হচ্ছে এরকম যে এরপর থেকে যত রকমের নতুন কিছু হবে সবগুলোতে এডিআরটাকে কোড বেস এবং যতটা পারা যায় ফ্রেন্ডলি করা। আমরা বিডিআর কাছ থেকে 2018 সালে একটা রিকোয়েস্ট পেয়েছিলাম, সেই রিকোয়েস্টের প্রেক্ষিতে আমরা সালিশ আইন 2001 যেটাকে আরবিট্রেশন অ্যাক্ট বলি আমরা, সেটার উপরে কিছু সংশোধনী দিয়েছিলাম। আমরা এখানে কৃতজ্ঞতা এবং ধন্যবাদ জানাতে চাই বিয়াককে, কারণ বিয়াক একটা এইটার উপরে একটা পুরো দিনের সেশন করেছিলেন, একটা সেমিনার করেছিলেন আমাদের এই অ্যামেন্ডমেন্টের উপর এবং ওনাদের মতামত দিয়েছেন। আমরা এটা এখনো ফাইনালাইজ করিনি
আমার দুইটাই
এবং
অ্যালটমেন্ট দুইটাই
সেক্ষেত্রে একটু ডিস্টার্ব করছে, কেউ মনে ঢুকে পড়েছেন, কেউ মনে ঢুকে পড়েছেন, সরি। হ্যালো হ্যালো, এখন কি শোনা যাচ্ছে আমাকে? হ্যাঁ, তো তাহলে যদি আমরা ওখানে ওই জিনিসগুলো দেখিয়েছিলাম যে ওই সালিশ আইনের মধ্যে যদি আমরা টাইম ফ্রেম করে দেই যে এই কয়েকটা সিটিং এর মধ্যে শেষ করতে হবে এবং ফিসটা যদি আমরা ফিক্স আপ করতে পারি তাহলে এটা অনেক বেশি ফ্রুটফুল হবে সালিশ আইনের মাধ্যমে যে সমস্ত ডিসপিউট রেজুলেশন গুলো হয়। আমরা ওই সময় একটা ওখানে আমি একটা আমাদের একটা তথ্য পেয়েছিলাম এরকম যে 2 কোটি টাকার একটা ডিসপিউট, কমার্শিয়াল ডিসপিউট, দেখা গেল যে 1,75,00,000 টাকায় আম্পায়ারের ফি হিসেবে চলে গেছে। তো সেরকম যদি হয় তাহলে তো এটার কোনো ফল আমরা পাবো না। এইটা হচ্ছে আমার বলার কথা। আমি মোটামুটি আমার যা বলার এটা শেষ করতে পেরেছি। তো এর মধ্যে আমি এটা এই যে প্রতিপাদ্য আপনারা বলেছেন যে এটা ফাস্টার করা সম্ভব কিনা, কোর্ট বেস এডিআর ক্যান ক্রিয়েট ফাস্টার অ্যাক্সেস টু জাস্টিস, এটা সম্ভব যদি এই যে প্রস্তাবগুলো আমি দিলাম এগুলো আরো কিভাবে প্রয়োগ করা যায় তাহলে এটা করা সম্ভব। এবং এটা করা হলে আমাদের মেইন স্ট্রিম বা ট্রেডিশনাল অ্যাডজুডিকেশনের যে প্রসেসটা আছে এটার উপরে চাপ কমবে। এবং কেবল যেগুলোতে কমপ্লিকেটেড ল রিলেটেড থাকবে, ল থাকবে, সেগুলোই শুধু আমরা ফর্মাল অ্যাডজুডিকেশনে দিতে পারি। যেগুলোতে এরকম কমপ্লিকেটেড ল থাকবে না, কোশ্চেন অফ কমপ্লিকেশন অফ ল যদি না থাকে তাহলে সেগুলো আমরা অবশ্যই এডিআর এ শেষ করতে পারি। এগুলো দিয়ে করতে গেলে আমাদের সময় এবং অর্থ সবকিছু বাঁচবে, অনেকগুলো এডিআর এর যা যা সুফল আছে সবগুলো আমরা এটাতে পেতে পারবো। তো এই হচ্ছে মোটামুটি আমার কথা। আপনাদের সবাইকে ধন্যবাদ।
Thank you, Azim. About the court-based ADR, it has pros and cons, but in England, 100% cases has to be tried before going to any court. We don't have any such provision. So we insist upon institutional ADR even before going to the court. If you can dispose of the cases before going to the court, matter is over. But once you lead somebody as a must, as a mandatory provision to go first to the court for court-based ADR, being directed by ADR, and if somebody fails after the court-directed ADR, that will be an additional dispute resolution forum, not alternative. So we carry on debating. Thank you for your deliberation. Now I would invite Mr. Kazi Arifuzzaman, who is the Joint Secretary in the Legislative and Parliamentary Affairs Division. He had his honors and masters in law from University of Dhaka and LLM in maritime law from University of Malta. Prior to his joining government service, he was a practicing lawyer in the High Court Division. He was trained in Canada on legislative drafting and traveled to many countries, including USA, UK, Russia, Australia, India, Singapore, Switzerland, Germany, and Turkey on various training programs and study tours. Kazi Arifuzzaman, the floor is yours.
Thank you, sir. Honorable Moderator, Honorable Chairman BIDA, Honorable Secretary Legislative and Parliamentary Affairs Division, Honorable Secretary Law Commission, Honorable guests, ladies and gentlemen, the panel discussion, Assalamu alaikum and good afternoon. It's a matter of great privilege and pleasure for me to be here with all of you as a participant in the panel discussion on the seminar titled ADR Can Create Faster Access to Justice. Before going in details, the legal legislative frameworks in Bangladesh, I would like to draw the attention of this session, the civil court system in Bangladesh. As we know, Section 9 of the CPC provides that court will try suits of civil nature where the lawsuits are involved in the nature of civil disputes or to an office. a suit is to be instituted by presentation of a plaint. The plaint must contain particulars to be included therein. And if a plaint requests to include all those particulars, then it is to be returned or rejected. The plaint is to be examined by the court, and a maintainability hearing may take place on that point. Soon after the maintainability, the question of summoning the defendant may arise, and after service of summons, a date may be fixed for claim to be filed by the counterclaim or the written statement to be filed by the defendant. When the written statement is filed by the defendant, it preferably within 2 months, then the question of issuing framing the issues may arise. But before that, by introduction of Section 89A in 2003 and subsequent amendment, the ADR process is introduced. And this is in the form of mediation, which is informal, non-adversarial, non-binding, and consensual in nature. In case of failure of ADR, then the question of the appearance of parties to the suit or consequences of non-appearance, recording of evidence, and argument, counter-argument may take place. And by this time, there is a question of adjournment, which may take place 6 times, and compensatory cost may be awarded in favor of a party or dilatory tactics to be avoided. But despite this fact, we have witnessed that the traditional court system is not inexpensive or hassle-free manner. It is cumbersome, and we cannot avoid the processes dealt with the CPC or the civil rules and orders. Our experience says this, by introduction of alternative dispute resolution mechanism, we can foster access to justice. And say, for example, the Family Court Ordinance 1985. This is most successful one in our legal system. Family Court Ordinance 1985, in its section 10, 11, and 13, giving the parties an opportunity to mediate. And it is successful in the sense that there was a pilot project. There was no less than 16 pilot projects in 16 districts in between the period of 2000 and 2001. And it is found that no less than 35 of the total pending cases are disposed of by ADR. Whereas in prior time, in between the period of 1985 to 2000, the disposal rate by ADR was only 1,000. It shows that if we can promote the ADR process and sensitize the judges, courts, litigants, and the lawyers as well, the speedy disposal is a must. The lack of reluctance, the lack of interest of the lawyers and other involved, the main factors in litigation process, they must have to be mindful as to the dispute resolution mechanism in alternative way. Otherwise, there will be cumbersome and ineffective judicial system, which may lead to chaos, confusion in the society. We can refer to the matter as contained in Section 89A of the CPC, which is flexible, informal, non-binding, confidential, non-adversarial, and consensual in nature. And it has been made compulsory by an amendment in 2012. And after filing the written statement, the court may, where the parties are represented in person or by their respective leader, they may be allowed to continue the mediation, and the court may facilitate the same. This is a privileged communication. In fact, the admission on the conversation communication made therein must be kept confidential and preserved under Evidence Act. And if it fails, then the fresh adjudication process in adversarial nature may start therefrom. The Arbitration Act 1940 was repealed by reenactment in 2001, and the ancestral model law on arbitration was followed in this country. And in most of the commercial disputes and incidental matters, there is a provision in the concerned contract that the matter be referred to arbitration where there is dispute. And the detailed provision of appointment of arbitrator is laid down there. The Money Loan Code Act 2003, which provides for mediation in Section 22, of the author in Adalat. And the parties to the dispute may refer to settle the dispute through mediation. But this is to some extent cumbersome in the sense that the person or the officer appointed by the board of directors of the banks, they may not have detailed authority or enough authority to settle down the dispute. Apart from this, the Family Laws Ordinance 1961, it provides for the ADR process in the sense that the dower, divorce, and maintenance issues may be referred to the Board of Arbitration, which is to be presided over by the UP chairman or the mayor of the Purushabha, as the case may be. Village Court Act 2006 also provides for the same provision of this alternative dispute settlement as to the civil or criminal matters as contained in the schedule, but they cannot exceed or pronounce judgment in matters compensatory cost in exceeding 25,000 taka, and they cannot impose imprisonment, which is var. Apart from this, the Conciliation of Dispute Municipal Board Act 2004 also provides for the dispute settlement mechanism. The Labor Act 2006 provides for the dispute settlement mechanism in the form of negotiation, arbitration, conciliation, etc. Thereafter, we can refer to the Legal Services Act, which provides in Section 21A by appointment of legal aid officers to which an application may be filed or the matter may be referred to through court for mediation. Section 152 of the Income Tax Ordinance, which was introduced in 2011 by Finance Act of 2011, that refers to the process of facilitation in the form of alternative dispute resolution on tax matter. But the assessee must have to submit the reports on income tax on the relevant financial years. He must have to comply with the provisions laid down by NBR. He must have to submit the documents, and there must be no untrue or false statement by him. In case of arriving an agreement which is obtained by fraud or otherwise, a legal proceeding may be started against the person or the assessee who provides the same. Apart from this, the Customs Act 1969 provides for the alternative dispute resolution mechanism, and the VAT Act 2012 and the rules framed there under in 2016 also provides for the ADR mechanism. Now, sir, I would like to refer to all the details provisions of the law as we are working on the legislative framework in the governmental system. And my junior colleagues who are the panel discussant in this session, Mr. Jannatul Ferdoush, she will be speaking on Muslim Family Law Ordinance 1961, Family Courts Ordinance 1985, Legal Services Act 2000, Conciliation of Disputes Municipal Board Act 2004, Village Court Act 2006, and my junior colleague who is also a panel discussant, Mr. Asaduzzaman, he will be speaking on Income Tax Ordinance, DAT 2012, Customs Act 1969, Labor Act 2016, EPZ Labor Laws 2009. And also my brother colleague.
Thank you, Kazi.
Yeah. And another two officers will be speaking the remaining legal framework and international legal framework, that is Mr. Abdul Halim and Mr. Atiqur Rahman Zamaly. With these few words, I would like to conclude, sir, because there are so many legislative and legal frameworks available in the country, we must have to make it effective, and we must have to build up awareness in the society. The litigants and the lawyers community must not feel reluctant, and they must be brought in the main track of alternative dispute resolution mechanism, and thereby we can make an effective legal system and the constitutional mandate of the country may be fulfilled. Thank you, sir. Thank you all.
Thank you, Kazi Arifuzzaman. You have rightly said that traditional courts have their limitations, and you have given some suggestions. We'll take in all these things. Now it will be the turn of Ms. M. Jannatul Ferdoush, who is a Deputy Secretary, looks after drafting in the Legislative and Parliamentary Affairs Division of the Ministry of Law. She had her honors and masters in law from the University of Dhaka. She was trained in Malaysia on legislative technique and visited Republic of Korea, Myanmar, the Philippines, Italy, India, and Canada on training programs and study tours. Ms. M. Jannatul Ferdoush, the floor is yours.
Thank you, Honorable Moderator, for giving me the floor. Honorable Secretary, Legislative and Parliamentary Affairs Division, Honorable Chairman, BIAC, distinguished discussions, my dear colleagues, ladies and gentlemen. Assalamu alaikum and very good afternoon. It is a great honor for me to be here with all of you. I want to convey my heartfelt gratitude to BIAC as well as LPAD to arrange this webinar on ADR can create faster access to justice. Rule of law and access to justice are main elements of a state for the stability and development. The existing legal process of Bangladesh is cumbersome, time-consuming, and costly. On the other hand, ADR mechanism is cheaper, quicker, and user-friendly rather than courts. The insertion of the provisions of ADR in many laws of the country has opened the door to access to justice. Our Honorable Secretary and other panelists already mentioned a series of laws which are relating to ADR. I'd like to share 5 specific laws among them that are Muslim Family Laws Ordinance 1961, Family Courts Ordinance 1985, Legal Aid Services Act 2000, Conciliation of Disputes Municipal Areas Act 2004, and Village Courts Act 2006. Firstly, ADR under Muslim Family Laws Ordinance, which are commonly known as MFLO. MFLO made an arrangement to settle family disputes among couples through quasi-formal local bodies that is called Arbitration Council. The Arbitration Council is constituted by the chairman and representative of each of the parties. MFLO provisions for reconciliation or ADR through Arbitration Council has been provided for in 3 circumstances. In case of polygamy under Section 6, in case of giving talaq or dissolution of marriage and making it effective under Section 7, and in case of failure of the husband to provide maintenance of his wife under Section 9. Now ADR under Family Courts Ordinance 1985. We all know that in Bangladesh for the first time the provisions of ADR was incorporated in Family Courts Ordinance in the year of 1985. Within the formal judicial system, the scope of mediation through the Family Courts Ordinance has been tested with positive results. The reason is that the process entails direct participation of the parties to the dispute. They are required to attend confidential meetings along with the lawyers and other interested persons in the presence of a neutral third party. A judge is trained to facilitate dispute resolution. Important factor is that the process is particularly beneficial for women litigants who have the opportunity of voicing their grievances without having to go through the embarrassment and discomfort of appealing in court. Provisions of ADR in this law has been incorporated in Section 10, 11, and 13 of the said ordinances. Now ADR under Legal Aid Services Act 2000. The provisions relating to ADR were incorporated in the Legal Aid Act in the year of 2013 by inserting Section 21A to the Act. In order to give effect to Section 21A, subsection 2 of the Legal Aid Act, the government has promulgated a set of rules in the name of Legal Aid, Legal Advice, and ADR rules, 2015. Legal Aid Services Act 2000 inserted a very special feature of the Bangladesh legal aid system is to appoint a judicial officer as mediator for the first time.
there is defect in the system, perhaps. Is this any defect in the system?
Anything wrong, Rubaya?
Sir, Jannatul Ferdoush madam's internet connection seems unstable, which is why she got disconnected.
Jannat, can you hear? Jannat, can you hear?
She's unable to join because she is disconnected at the moment.
Jannat, carry on. Hello.
We have her.
Your microphone is muted, Jannat. You carry
Okay,
on.
okay. Can you hear me, sir?
Yes, now it's all right. You carry on,
Okay.
and I will request you to finish as early as possible. We are running out of time.
Okay, okay, sir. The Conciliation of Disputes Municipal Areas Board Act 2004. The Act establishes a dispute resolution board for easy and speedy settlement of a number of disputes in municipal areas through conciliation. In the proceeding of the municipal board, CPC, CRPC, and Evidence Act will not be applied, and no party can engage any advocate in such proceeding. Now, Village Courts Act 2006. Rural system of Bangladesh has a long and eventful history. Village court is a part of rural system in Bangladesh. We all know that village court is also known as ADR court, is one kind of hybrid of formal and informal dispute resolution mechanisms. It is constituted under Section 5 of the Village Court with 5 members, where 1 chairman and 4 members are to be nominated by each of the parties to dispute. In this stage, I would like to share another statistics regarding village courts performance. July 2017 to October 2020, source is activating village courts in Bangladesh phase 2 project of LGD division, local government division. Dispute received in this year, 211,373. Application directly filed at Union Parishad, 201,191. Cases transferred from district courts, 9,982. Pending dispute before implementation of project, that is 30 June 2017, 2,340. Application filed by women, 62,393. Women in decision-making process, 47,129. Money recovered as compensation, 1,72 crore. In USD, 20 million. In Bangladesh, after the insertion of the ADR in the above mentioned law, has acquired a great success in this field. With these few words, I'd like to conclude. Thank you all for your patience hearing. Thank you.
Thank you very much, Jannat, for your overview. And I would now like to invite Saqeb Mahbub, partner Mahbub and Company, who is an advocate of the Supreme Court of Bangladesh. He's a corporate and commercial lawyer. Barrister Mahbub advises and represents clients on corporate, employment, contract, investment, mergers and acquisitions matters. He started his career at Hossain Company, where he was a part of the litigation and arbitration team. During his time there, he advised a major US bank on financial laws in Bangladesh. Barrister Saqeb Mahbub, the floor is yours. Barrister Saqeb Mahbub, hello.
Yes, hello.
Yeah, thank you.
Hello. Thank you, Honorable Director, BIAC, Honorable Secretary, LPAD, Honorable Chairman, BIDA, and other distinguished guests and panelists. It is an honor to be amongst you, be amongst this distinguished panel and audience. I would thank BIAC for organizing this this very topical webinar, ADR, covering ADR and access to justice, two very important concepts in the context of Bangladesh. So what is ADR and access to justice? I will first just talk about very briefly about the differences in these concepts And then I will go into the meeting points and where these concepts can converge. First of all, the access to justice movement that Bangladesh, the government has been working towards, tries to solve the problem that not everyone in society gets access to justice or gets the benefit of the law, or there are huge delays in getting justice and the benefits. The ADR movement is slightly different in the sense that it tries to promote something else, which is an out-of-court system of resolving disputes. So while the access to justice movement is not necessarily concerned about ADR, as long as justice is obtained, ADR tries to promote alternative ways of out-of-court resolution of disputes. It can be arguably said that in access to justice, the justice is the final goal, while in ADR, the resolution of the dispute is the final goal. So one can argue that these are two different concepts, but I would argue that in the end, these are very similar concepts and have very similar challenges and ultimately have very similar solutions. Because just helping someone, helping a litigant or helping a justice seeker access the court system does not give him justice. In the end, the litigation or arbitration or whatever the resolution system is, it has to end. And only at the very end will there be justice. And what ADR does is it brings the end closer, it brings the end nearer and makes it quicker to get to that point where the dispute is resolved and justice prevails. Access to justice concepts in Bangladesh we have traditionally focused on solutions like legal aid, which is obviously important. There are litigants in Bangladesh who don't have access to funds which can help them access the court system. But while that is very important, it falls short of ultimately getting the justice for that particular justice seeker, because it may take years and years to finish a case, and then when the case is finished at the subordinate court level, that there's appeals and revisions, so it can take a long time. And ADR tries to solve the problem of delay. It tries to solve the problem of appeals and revisions because it tries to create a solution which is acceptable to both parties. And our legal system and the Ministry of Law, LPAD, has promoted ADR in the past decade, and I have worked closely with LPAD in one capacity as in the UNDP project promoting access to justice and human rights. I had worked with the then Honorable Secretary, Mr. Shoidul Haq. And I have seen closely how LPAD is resolved to promote ADR in each and every opportunity that it gets. We have seen successes with the family courts, where the court itself sometimes takes on the role of a mediator. It encourages the parties to mediate because there is a common goal of sometimes the welfare of the child is the common goal. And in that common goal, the two parties can come together. There is an opportunity which family courts avail. There is the 2010 Real Estate Development and Management Act, which has provided for mandatory arbitration. And that, I would say, has seen a lot of success because there's now a lot of arbitration which stems from that act, again, it works because there is a common goal. The usual disputes under that act are between landowners and developers. So both have a common goal that the building is constructed and they can both sell their particular, their share of flats. So when there is a dispute, they both have a common goal towards finishing the construction of the building. And in that context, the ADR method actually has played a good role, and it has been well received, I would say, by all parties. There have been other success stories, I would say. One is the Bangladesh Energy Regulatory Commission, which resolves disputes between customers and electricity service providers. Another one, which is more works with more of the at the root level, is the Consumer Protection Act, which gives consumers a chance to file cases or file complaints against businesses which violate the Consumer Protection Act. These have seen quite a lot of success. There has been challenges with some of the ADR mechanisms. For example, the Orthorin Adalat Ain. I will get into why I think there is challenges with the Orthorin Adalat Ain, and why the ADR mechanism in that Ain does not work. But before that, I would like to address something else, which is what is the reason why the parties will want to go to ADR. And if we are creating if our legal system, if our legislation, if our judicial administration is creating a proper environment for ADR. So I would just take 30 seconds to tell a story which is better said in Bangla. It is that if Honorable Director allows me, ekjon mokkel gelen ukiler kache. তো উকিলকে গিয়ে বললেন যে আমার একটা মামলা করে দিতে হবে। তো উকিল সাহেব বললেন যে এই মামলাটা তো চলে না, আপনার মামলায় কোনো মেরিট নাই, এই মামলা চলবে না। তো মক্কেল ডিসঅ্যাপয়েন্টেড হয়ে উনি গেলেন আরেকজন উকিল সাহেবের কাছে। তো আরেকজন উকিল সাহেব বললেন যে না, এই মামলা চলবে। তো উনি মামলা ফাইল করলেন। মামলা ফাইল করার পরে সেই মামলা উনি জজ কোর্টে হারলেন। তারপরে উনি হাইকোর্টে আপিল করলেন, সেখানেও হারলেন। অ্যাপেলেট ডিভিশনে গেলেন, সে অ্যাপেলেট ডিভিশনেও গিয়ে হারলেন। মামলা 15 বছর চলে গেল, পার হয়ে গেল। তখন মক্কেল গিয়ে জিজ্ঞেস করলেন উকিল সাহেবকে যে আপনি তো বলেছিলেন যে মামলা চলবে, এখন তো অ্যাপেলেট ডিভিশন বলে দিল যে এই মামলা চলে না। তো উকিল সাহেব বললেন যে চলে না, তো তাহলে 15 বছর চললো কিভাবে? তো the case ran for 15 years. It is a story, but it is also the reality of many cases stuck and in our judicial system, and it is clogging up and creating backlogs in our legal system. There are I have identified 4 losers in that situation, in that scenario where this case ran for 15 years when it shouldn't have even been filed. One loser is the person who loses the case, the client who went to the lawyer and he ultimately loses the case. Another one is the person who wins the case. Why he is a loser? Because he had to wait 15 years to get his result, to know that he has won. So he had to wait 15 years. He had to pay lawyers' fees. He had to suffer for 15 years, mental agony. Another third loser is the taxpayer, because the taxpayer is funding the judicial system, and valuable time of the judicial system has been wasted because this frivolous case went through the legal system and wasted taxpayers' money. The fourth loser is other justice seekers. Because of this case and other frivolous cases like this were clogging up the system, other justice seekers faced delay. They could not get their relief in time. Now, I identify this problem of frivolous cases as one of the biggest problems to both access to justice and ADR. Why is it a problem? The problem is our legal system, our judicial system is not efficient or our legal system allows frivolous cases to clog up the system. It cannot weed them out at the initial stage, and even at the end, it does not punish people who bring these frivolous cases or who frivolously defend good cases. So there's 2 aspects. One can be that the plaintiff has a good case, but the defendant is frivolously trying to defend his case and takes it up to the highest level of court. And then other situation is where the plaintiff has a bad case and he's trying to take it to the highest level of court.
Mahbub, I'm afraid of time. Can you finish in 30 seconds?
Yes. Yes. 1 minute. 1 minute. So my point is that the frivolous litigation has to stop. And there's two ways of doing this. One is summarily reject these cases, and another is penalizing the party at fault at the end by imposing heavy costs. Both these weapons are there with our judges. However, they are not used very frequently. So the weapons to stop these frivolous cases are there. And once these frivolous cases are stopped, one, justice will be quicker, and two, people will be more encouraged to go for ADR, because they will know that going to the justice system will not result in any delay, and so they have to resolve their cases. It is better for them to resolve their cases outside of court, and in the end, everyone will benefit, and the four losers that I have mentioned will not lose anymore. Thank you, Honorable Director. Thank you, audience, for listening.
Thank you, Mr. Mahbub. You have rightly said that though it looks two different connotations, the ADR and the access to justice, but at the end of the day, both have the similar aims. We look forward to working together with your chamber, and I insist on accountability for lawyers and improved case management at courts. Both will contribute to integrate ADR processes with the judicial infrastructure of the country. I'm hopeful. Now, I'm about time. We have already passed the allotted 90 minutes to finish the webinar. Now, I would request the remaining three speakers from the Legislative and Parliamentary Affairs Division, please not to go by the laws you have planned to discuss one by one. Rather, I would insist on your personal views on the things you have planned to produce here. Now the turn is of Mr. Mohammad Asaduzzaman, who is the Deputy Secretary Drafting in the Legislative and Parliamentary Affairs Division. He had his honors and masters in law from University of Dhaka and Master of Human Rights and Policy from University of New South Wales, Australia. Prior to his joining the government service, he was a practicing lawyer in the district court. He was trained in India on legislative drafting and visited Sweden, UK, Republic of Korea, South Africa, and Ethiopia on training programs and study tours. Mr. Noor.
Thank you, sir. Distinguished Chairman of BIAC, respected Secretary, sir, and dear colleagues and audiences, very good afternoon. So can I share my slides? Is it possible? Or yeah, thank you. Thank you. Thank you, sir. In fact, I try to be within time, so I'd like to go fast. We know that goal 16 of the SDG, that is access to justice for all. Now I'd like to share that, that access to justice, it is said that justice delayed is justice denied. So it is a common phenomenon in our country. Access to justice has different facets and different components. Easy access to court and speedy disposal of cases is one of the most vital components. And definitely ADR is one of the most effective mechanisms to resolve a dispute without recursing court, or sometimes by recursing the court. In fact, my focus would be on revenue sector and labor sector. So we all know that the conventional system, in our conventional system, it is full of procedures and complexities. It is like a maze. That means we have to follow a lot of ways to reach our destination. Here, judges rule like an umpire of a game. That's why the team which play well, definitely that team will win and the other team will lose. That is the conventional system of our court. I just would like to share that the revenue sector is not out of this conventional system. Here is also there are a lot of procedures there. So first of all, there is a system of order by the Deputy Commissioner of sometimes it is tax, maybe it is customs or VAT. Then if a party is aggrieved, or if a person is aggrieved by the order of the Deputy Commissioner, then he goes to the Commissioner. Again, if still the party is aggrieved, then he has the opportunity to go tax appellate tribunal. And again, aggrieved by the order of the tax appellate tribunal, he can go to the High Court division, and finally he can go to the appellate division. You see, there is also a time allocation. You see, a order is normally given by DC. It takes almost 1 year, Then commission of tax, it takes almost 9 months sometimes. And tax appellate tribunal, it takes 10 months, sometimes 1 year or more. And if a party goes to High Court division or appellate division, there is no time limit. In fact, these are all regulated by their own rules and regulations. So you see, in these cases, in order to get a order, party has to wait for a long time. So this is the picture of our conventional system. I recently see a report in Bangladesh Pratidin where it reports that in revenue matter, there are almost more than 27,000 cases are pending before the court. And if you convert it into amount, it is amount more than 41,000 crore taka. So it's a big amount of money that is unrealized due to all these cases. And in this slide, you will see that there is a comparison. In fact, I will not go in depth because time is very limited. So if you wish, then you can have a look it. So this is the scenario. And in this backdrop, the government of Bangladesh, like the other sectors, especially like CPC and money loan or other sectors, the government of Bangladesh also introduced ADR system in revenue sector in 2011 and 2012. So here you see, in this, we all know that ADR process, there is no win or loss. In fact, it is win-win situation. So you see the picture, they uphold a trophy and they are sharing with each other. There is no win or loss. Here is a comments by ADR. In fact, it is comments by NBR that the alternative dispute resolution is a process of resolving disputes within shortest possible time beyond the regular course of business followed by appeal tribunal court. So in fact, NBR also trying to resolve the disputes through ADR, not going to the court. That is the main object to introduce ADR system in this court. You see, there is a provisions for ADR in the 3 laws. I would not say about details because we all know about the provisions of the ADR. I like to share some statistics. In fact, how many cases are. In fact, I just have a very brief look about how ADR is working in this sector. In fact, there is a system of appointment of a facilitator by the respective department of tax, VAT, or customs, and in fact, the facilitator will facilitate the concerned parties and the representatives from the respective department of NBR so that they can reach a solution. And by this way, in fact, they are working in very informal way so that they can reach a settlement. Here you see there is a statistics. In fact, in 2012, the ADR system is introduced in tax sector, and you see during between 2012 and 2018, there is a gradual increase of ADR cases, and there's also a number of cases are resolved through ADR. But after 2018, it is you see it is decreasing. It is decreasing in tax cases. And if you look to customs, till today, between 2012 and 2020, there are 134 cases have been filed for ADR, and the amount is 71.68 crore taka. But the cases is resolved through ADR is 115, and VAT there is 42 cases are referred for ADR, and it is only 23 cases are resolved through ADR. You see here is a slide. Time is very limited, so I will not share my detail about this slide. But here you see that the number of cases are huge, but a very few or insignificant number of cases are resolved through ADR. In fact, then the question comes: why people are not interested to go to ADR? There are a lot of reasons. You know that NBR. In fact, there is a. In fact, these are all cases related to money. So sometimes you see that parties are not willing to go to ADR, and sometimes they are in fact inclined to go to court because they are. My previous discussion said that sometimes the unscrupulous, especially the lawyer or the practitioners, they also misguide the clients, and sometimes they file their cases and they just make it pending for a long time so that they can get benefit from the cases. So in this NBR sector, this is the very common scenario. That's why the people are not going for ADR. And now I'd like to focus on labor law. You know that in our country, the Labor Act 2006, and there is another act that is called Bangladesh EPZ Labor Act 2019. It is in fact for the EPZ and the economic zone labors. So these two law lays down provisions almost in the same language for negotiation, conciliation, and arbitration. Under EPZ Labor Act, there are 60 social counselors, in fact, are working. They can give suggestions or advice to the workers as well as to the employers so that they can come to resolve their disputes through ADR. 3 conciliators and 3 arbitrators are also working to resolve the disputes. And from the statistics of BABZA, I have statistics that as of today, 161 cases have been filed for ADR, and out of them, 86 cases are in fact resolved through ADR. There is another statistics from Labor Act, that is 2006. It is also, I have come to know from the Department of Labor that till today, there are more than 20,000 cases are pending before different courts and tribunals, and 144 cases are pending before the High Court Division under this Labor Act. And we will see how many cases are resolved. Here you see that though Labor Act says that the cases has to be resolved or has to be disposed of within 60 days, but in many cases we see that sometimes the party has to wait for a long time. Sometimes it is more than even 7 to 8 years.
Thank you for your insight. You have discussed.
Okay, thank you, sir. In fact, these are all about the statistics of labor as well as the NBR sector. Thank you. Thank you for giving me the opportunity.
Context, VAT and customs, you have identified rightly the problems and suggested a few measures for improvement. Thank you very much, Noor. Now I would request the last 2 speakers, Mr. ZM Atiqur Rahman Zamaly and Mohammad Abdul Halim. I would request them to confine their deliberation in 5 minutes. We're already ran out of time. Our chairman is waiting to close the session, and we cannot go beyond 2 hours in any case. It is already 100 minutes. So I would request Mr. Zamaly to be very brief. Mr. Zamaly is the Deputy Secretary of Drafting in the Legislative and Parliamentary Affairs Division. He had his honors and masters in law from the University of Dhaka. He was trained in India on legislative drafting and traveled to Italy, Belarus, Thailand, and the Philippines on training programs and study tours. On to Mr. Zamaly.
Thank you, sir. Assalamu alaikum and good afternoon. Today we are few people attending in this webinar for millions of persons who are eagerly waiting and thinking alternative way of getting access to justice faster. In Bangladesh perspective, many of them already spends double-digit years but fail to get justice. Even they don't know after spending how many years they may get justice. Today I would like to focus on international legal regime regarding ADR. We know some states may form a common legal forum under a convention or an agreement. This type of forum also may adopt an international arbitration agreement. This sort of international forum creates an international legal regime that significantly favored the enforcement of international arbitration agreements and awards. United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Award, 1958, which is known as New Year Convention, is the example of a legal regime. United Nations Commission on International Trade Law, UNCITRAL, is another predominant example of a legal regime. International institutions like United Nations, World Intellectual Property Organizations, and International Trademark Association creates ADR body under its own framework. We can mention some ADR institutions established under the international platforms like International Chamber of Commerce, ICC, World Intellectual Property Organizations, WIPO, International Center for Settlement of Investment Disputes, ICSID, Permanent Court of Arbitration, PCA, and International Trademark Association, INTA. Some regional countries also may form an international association or forum that creates its own international legal regime. NATO European Union, ASEAN, African Union, BIMSTEC, SAARC creates its own ADR forum. As per Article 7 of NATO Charter, it can appoint arbitrator to settle disputes. European Union established its own Court of Arbitration in 1992. Even ADR process played a strong role in British exit from European Union process, which is widely known as Brexit process. The United Nations Conference on Trade and Commerce, UNCTAD, has taken initiative to alternatively resolve disputes by regional approaches. We can mention example of North Atlantic Free Trade Agreement, NAFTA, and Association of South Asian Nations, ASEAN. South Asian Association for Regional Cooperation, SAARC, has its own arbitration council named as SAARC Arbitration Council, or SAARCO. Sometimes a strong international ADR institution or bodies may be established in a country context, but for the purpose of international dispute resolution. Singapore Arbitration Center, SIAC, China International Economic and Trade Arbitration Commission, CITEC, London Court of Arbitration, LCIA, Hong Kong International Arbitration Center, HKIAC, Delhi International Arbitration Center, DIAC, and obviously Bangladesh International Arbitration Center, BIAC, is the best example. With the kind permission of the chair, I'd like to focus on ODR process for a few seconds. In the context of worldwide COVID-19 pandemic, many reputed international ADR institutions applying online dispute resolution, ODR process effectively. If this process is already adopted by the BIAC, then express my gratitude to them. But if not so, surely they can think of it. You know, now Bangladesh is the 33rd largest economy of the world as per PPP basis. By the 2040, Bangladesh will enter into world top 25 economic group. It indicates that our future international integration, expanded international trade commerce, geopolitical strategy, and diplomacy surely increase legal disputes in future. So we should think of our future legal challenges, and we should take preparation to build up strong international legal institutions. Dominance and extended strength in this arena may make Bangladesh dominant and strong in international forums. I would like to stop there. Thank you all.
Thank you, Zamaly. I would now request the last speaker, Mr. Mohammad Abdul Hamid, who is a Deputy Secretary in charge of drafting in the Legislative and Parliamentary Affairs Division. He had his honors and masters in law from University of Chattogram. He was trained in Nepal on international humanitarian law. Prior to his joining government service, he served as lecturer, Department of Law, Southern University, Chattogram. Mr. Halim.
Thank you, Honorable Moderator, Honorable Chair, and esteemed participant. Assalamu alaikum and good afternoon to all. At first, I would like to thank the organizer for organizing such an important webinar on ADR. In recent years, in Bangladesh, there has been renewed emphasis on the ADR schemes as a means to avoid the use of contested hearings in the formal litigation and to ensure the most fundamental right of access to justice for all in an easy way. The ADR may serve the interest of the state and business in many ways. First, ADR reduces burden on courts and adjudication process by resolving disputes at an early stage. Second, by reducing workload of judges, it allows sufficient time in dispensation of justice in other matters, raising the standard and quality of justice. Third, by reducing backlog of pending cases, it serves huge revenue. Fourth, ADR works as a contraceptive to the field of unnecessary jungle of litigation, giving the legal system a healthy development. And fifth, when business partners and establishments find that business disputes may be resolved through a system otherwise than formal litigation, it gives a sigh of relief of business entrepreneurs and promotes business culture in the country. Now I am going to focus on ADR mechanism in the CPC. You know that ADR mechanism has been introduced in the civil suits by way of Code of Civil Procedure Amendment Act 2003. Mediation and arbitration have been inserted in section 89A and 89B of the Code of CBC. This act went through another amendment in 2006 that introduced the provision of mediation even at the appellate stage. These provisions have further been amended by CPC Amendment Act 2012, adding 2 new sections, 89D and 89E, and making the provision of referral to ADR of all civil cases mandatory. However, there are some fundamental shortcomings, in my opinion, in the ADR process introduced by the CPC. Number one, absence of mechanism of compelling appearance of the parties for mediation. In subsection 1 of section 89A, it is stated that after filing of written statement, if all the contesting parties are present in the court in person or by their pleaders, the court shall, by adjourning hearing, mediate. But what will happen if both the parties or their pleaders do not attend courts together? Reality is that neither parties nor their lawyers attend the court together. If the lawyer of the plaintiff attends, lawyer of the defendant does not attend, and the courts have no other option but to give date one after another. This problem is supplemented by another problem. Suppose lawyers of both the sides appear and the court makes an order for appearing before a mediator for settlement or ask themselves to mediate and report the court, the parties or party does not attend mediation. What is the consequence? This makes the span of dispute lengthier only. The court has not given any power to impose any penalty or measure, as this is the stage even before first hearing. Number 2 shortcoming, absence of measures for not attending mediation or not compromising. There are many cases where the lawyers of both the parties attend mediation meetings daily. The mediator suggests a compromise between the parties, however, one party does not want to compromise. In such a case, the mediator has to give a report of disagreement. There is no measure to be taken against the party who is unreasonably withdraws from compromise. In such a situation, the court should be armed with power to impose fine to the unreasonable defaulting party. Now I am going to focus on the Arthurin Adalat Ain. Section 22, Section 22 of the amended Arthurin Ain incorporate the provision of mediation almost in the same words and manners as is provided for under Section 89A of the CPC, but with the exception that in Arthurin Adalat, a special resolution providing for authorization of the board of the directors of the concerned financial institution authorizing one of its officers must be passed and submitted with the concerned Arthurin Adalat. The Act takes one step ahead of the CPC under Section 22 in the sense that it provides for mediation provision not only at the appellate stage, but even at the revision and execution stage of Arthurin suit as well. Now I would like to draw your attention on the ADR mechanism in criminal justice system. ADR has not been yet widely incorporated in criminal justice system. However, Section 345 of the CRPC enacts provision for compromise between the adversary parties to a little extent. You know that subsection 1 of Section 345 provides a list of offences which can be compounded without the permission of court, and subsection 2 of this section provides the list of offences which can be compounded only with the permission of the court. ADR can be introduced in CRPC by enlarging the scope of Section 345 and inserting a new section and empower the criminal courts to dispose of criminal cases through ADR. Critics believe that ADR encourages compromise. Compromise can be a good way to settle down dispute, but it is not appropriate for others. Though there exists criticism, it is still helping the common people in getting the judiciary service cheaply. With these few words, I thank you to all. Thank you.
Thank you, Halim. We are done with all the eminent panelists. We have one question from Mr. Mohammad Hossain, who asked how much effectiveness is available by ADR for banks. Banks are, of course, getting the benefit of ADR through BIAC's intervention, especially in recovering the non-performing loans. We are getting cases from many banks in Bangladesh. Now to sum up, we have very little time left over. Our chairman is eagerly waiting to say a few words as a closing statement. We have heard a lot and we have learned how improvement can be done in the field of access to justice and how awareness can be built in ADR scenario. We think we'll be highly benefited by the deliberations once we translate it into texts and share with all the beneficiaries. We look forward to working with all our partners, including the government of Bangladesh, represented by the Ministry of Law for the Matter of the Legislative and Parliamentary Affairs Division. Now I would request our chairman to close the session Mr. Mahbubur Rahman is the current and founding chairman of Bangladesh International Arbitration Center, BIAC, and the BIAC board, an eminent businessman of the country. He is also the president of International Chamber of Commerce, Bangladesh. He is the only arbitrator in Bangladesh for the China International Economic and Trade Arbitration Commission, CITAC. Mr. Rahman is the chairman and CEO of ETBL Holdings Limited and chairman of the International Publications Limited, publishers of the daily Financial Express. Mr. Chairman, sir.
Thank you. First of all, let me take the privilege of greeting all our colleagues who have joined us today in this webinar. And I must say that the Bangladesh International Arbitration Center has been very active even during this pandemic situation. And I understand there are a number of such webinars has already been organized by them, and there are some more in the pipeline. Thank you very much. And more importantly, those distinguished experts who has very kindly taken out their time from the busy schedule. And I would like to take this opportunity to say thank you, the Honorable Secretary, the Legislative and Parliamentary Affairs Division of the Ministry of Law and Justice, and the BIDA, Bangladesh International Arbitration Center. I do not see his photograph or the picture. Is he in the session?
Sir, we have him in the room. It's unfortunate that his video was off. He's here now.
Oh, is he there? Is he listening to me?
Yes, sir, he is.
Most likely he's there, but his video might be off.
Okay, that's okay. He has joined us. But thank you very much. This Bangladesh International Arbitration Center, and also for the BIDA. Possibly this is perhaps the first time, if I'm not wrong, that BIDA has joined in the promotion of investment as well as dispute resolution mechanism, so that we have our say to the foreign investors, whether the dispute resolution mechanism, how effective and useful in Bangladesh. And it is from that understanding, we three business organizations, this ICC Bangladesh, Dhaka Chamber of Commerce and Industry, and Metropolitan Chamber of Commerce and Industry, we joined together with the full support of our Ministry of Law and Justice to establish this arbitration center. And this is the first of its kind in the country. And we are working very closely, and more importantly, with the Legislative and Parliamentary Affairs Division for enacting new laws, amendments to the arbitral institutions. Just to say a few formal points, the respected Executive Chairman of the Bangladesh Investment Development Authority, respected Secretary, Ministry of Legislative and Parliamentary Affairs Division of the Ministry of Law, distinguished panelists, ladies and gentlemen, Assalamu alaikum wa rahmatullahi wa barakatuhu. As I already mentioned, that despite all these limitations under COVID-19 situation, the BIAC has been trying to organize national as well as international and regional such webinar in order to bring about a more speed to the what is called dispute resolution mechanism in Bangladesh. As you all know, that we have been overburdened with a lot of legal issues and a lot of cases, hundreds and thousands of such cases pending in the court, and it takes some commercial disputes more than 10 years, 12 years, 15 years, or even more. So from that point of view, there is no other alternative except for going into such alternative dispute settlement mechanism. And that is why the ADR is so very important for Bangladesh in order to bring about a resolution of the pending issues or the situation that we are, passing through. Bangladesh International Arbitration Center, as I have already said, it came into being in 2011. In fact, we have started our journey from 2003, but in real life, we came into operation in 2011. It's 9 years already completed. And from then on, we have signed agreement with a lot of international arbitration centers, and more importantly, the Permanent Court of Arbitration in The Hague. We are also the member of the what is called the International Council for Commercial Arbitration, that is also based in The Hague. And I must say, for all these specialized services, we are trying to take the full advantage and the expertise from all these institutions with whom we have signed memorandum of understanding, the agreement on cooperation on both sides. And we are also having, I take pride in some of the international institutions are taking notice of the existence of BIAC in order to bring about a resolution about the disputes that their people are having with us. In the current situation, we are having one case from Japan. We have already settled one case from Japan. We have already resolved one more in some other country. But nevertheless, it will take some time for us to make them understand that we are having all the facilities, including the laws and also our the rules, what is called ADR rules, as well as what is called ADR.
The arbitration and mediation rules.
Mediation. The mediation rules of our own, which has been revised in 2019, and it is very compatible with that of UNCITRAL, with that of any other institution worldwide. So therefore, anyone can rely upon all this, and this is the, as I said, the only registered arbitration center and recognized by the government. I would also like to take this advantage because this will be an important milestone for us. Excuse me. Because when the law, Justice and Parliamentary Division give their unequivocal support to the this ADR institution, we take also it with full pride and also try to take it ahead. Therefore, we shall be very happy to see that all other relevant institutions in the government who are promoting the foreign direct investment as well as local investment, whatever it may be, to bring them to the forum in order to avoid long-term hassles in the normal court of justice. I must say that we are aware that the goal of 16 Sustainable Development Goals pledges ensuring access to justice for all. You all know the SDG, out of their total number of 17, the 16, one is SDG, Sustainable Development Goals, ensuring access to justice for all. So from that point of view, we are also working towards the achieving that objective within 2030. Widening the access to justice depends upon existing some facilities to the litigants and empowering them to overcome those barriers. In the present day context of Bangladesh, we are of the opinion that ADR can create faster access to justice, integrating its methods, arbitration, mediation, negotiation, conciliation, etc., with the existing judicial system. What we have learned from today's valuable deliberations by eminent speakers will lead to a more pragmatic ADR landscape in the country, where the government will have a vital role to play along with the regulatory reforms and guidelines with a view to ensuring faster access to justice by the masses in general and the business community in particular. I am very much thankful and grateful to the Executive Chairman of BIDA, Mohammad Sirazul, and Secretary Legislative and Parliamentary Affairs Division, Mr. Mohammad Moinul Kabir, for their priceless thoughts and commitments to achieve our common national goal and economic development. My special thanks also goes to the Secretary Parliamentary Affairs Division, and also the Joint Secretary, Mr. Fowzul Azim. And we are thankful for, by your participation, by your presence, today's webinar has been made a meaningful one. Thank you very much once again, all the participants here, and some of the participants, as I can see in the picture, that they have joined us and supported us in our past initiative and has been working very closely with us. We only look forward to see that, like any other institution in other countries, in this area, that Bangladesh International Arbitration Center also makes this room in order to bring about a total change in the dispensation of justice, and more importantly, the dispute resolution in the business. And as you all know, here we have three partners. We have just mentioned three partners, that ICC Bangladesh, Dhaka Chamber of Commerce, and Metropolitan Chamber of Commerce. And all of you must be knowing that ICC runs the #1 dispute resolution center, which is called International Court of Justice, which has been in operation since 1928 or something. I do not remember exactly, but it is almost 100 years. So from that point of view, and we would also like to see that Bangladesh International Arbitration Center also provide that kind of a services, that ICC's Global International Court of Justice has been providing these services for decades. And I must say that at this point of time, we have more than $13 billion worth of cases that is under dispensation in the ICC headquarters. ICC having their center in Hong Kong, in Singapore, and a number of other international centers in order to bring about a change. I would like to say once again, Mr. Rumi Ali, our Chief Executive, Mr. Akmall Azad, Rubaya, all of you for your efforts in bringing out this webinar and to promote the arbitral center in institutions and avoid more and more going to the court to save time and also the money. I like to say once again, thank you very much for your joining.
Thank you.
Thank you very much, sir. Ladies and gentlemen, this has been a fantastic webinar today. And since we were, due to time constraints, we could not take any questions, but we did answer the one we received. And thank you so much for taking out time today on a Saturday, especially, to join us for this webinar. And we hope to see you again in our next event. Thank you so much. Assalamu alaikum.
Wa alaikum assalam wa rahmatullahi wa barakatuh.